The Supreme Court absolutely blows out affirmative action in a major ruling that the Harvard people are not going to like. You see here, Judge Clarence Thomas was in the majority. And this case involves the application process for different universities and how oftentimes they'll consider race specifically and other indicators before they admit somebody into their college. And so we're going to go through this opinion and take a quick look at the position from Judge Clarence Thomas. Here is what it looks like. So you can see this case is involving Students for Fair Admissions versus the Fellows of Harvard College. Certiorari granted via the First Circuit makes its way to the Supreme Court. This was argued October 2022, decided 2023, June 29th. The Supreme Court tells us this case involves two colleges, Harvard and North Carolina UNC, University of North Carolina, two of the oldest colleges in the U.S. Every year, tens of thousands of students apply to each school. Many fewer are admitted. And both these schools employ highly selective admissions process to make their decisions. Admissions to each school can depend on grades, recommendation letters, extracurricular involvement. It also depends on their race. Now, the question presented here is whether the admission systems used by Harvard and UNC are lawful under the Equal Protection Clause of the 14th Amendment, saying that the laws should equally protect all of us uniformly. At Harvard, each applicant for admission is initially screened by a, quote, first reader. This person assigns a numerical score in each of the 6 categories. We've got 6 categories here. One is academic, extracurricular is another one, athletic, school support, personal, and overall. Now, for the overall category is made up by a composite of 5 other ratings. A first reader can and does consider the applicant's race. Harvard's and their admissions subcommittees then review all the applications from a particular geographic area. And these regional subcommittees make recommendations to the full admissions committee, and then they take their race into account. So when the 40-member full admissions committee begins its deliberations, it discusses the relative breakdown of the applicants by race. So it's part of the incoming process, right? There's a couple layers of racial analysis here. It discusses the relative breakdown. Now, Harvard says the goal is to ensure that there's no dramatic drop-off in minority admissions, and an applicant receiving a majority of the full committee's votes is tentatively accepted for admission. At the end of this process, the racial composition of this entire batch of the tentative applicant pool is then disclosed to the committee. They treat people like trading cards. I've got, 2 pair here and 3 of a kind over here, and how many, it's really kind of a gross thing. But so at the end of this process, these very sophisticated, absolutely not racist people sit around and then they analyze a group of people literally based on their race. It's nuts. But the racial composition of the tentative applicant pool is then disclosed to the committee. So they go, oh gosh, a lot of white people here. Yeah. Oh, look at all these Asians. Oh man, all these Harvard people are talking like this, So the last stage of the Harvard admissions process is called the LOP. They're just going to go off. Asians and white people, off the top. So it winnows the list of tentatively admitted students to arrive at the final class. Applicants that Harvard considers cutting at this stage are placed on the LOP list, which contains only 4 pieces of information in this LOP list analysis: the legacy status, the recruited athlete status, financial aid eligibility, got to get that money, and race in the LOP list. In the Harvard admissions process, race is a determinative tip for a significant percentage of all admitted African American and Hispanic applicants. That's what happens in Harvard. Now, North Carolina has a similar process as well, but the students have an issue with this. So Students for Fair Admissions is a nonprofit organization whose stated purpose is to defend human and civil rights secured under the law, including the right guaranteed under the Constitution, which is called the Equal Protection Clause. The students filed separate lawsuits against Harvard and North Carolina, saying they violated the 14th Amendment and the Civil Rights Act. After separate bench trials, both admissions programs were found permissible under the Equal Protection Clause. In Harvard, the Court of Appeals affirmed. This court granted to hear the case. So the court now rules, but writing the opinion of this court is Judge Roberts. He delivered the opinion of the court, and it is a split directly across party lines. Thomas, Alito, Gorsuch, Kavanaugh, Barrett joined. Thomas filed a concurring opinion. So did Gorsuch. Kavanaugh filed a concurring opinion. Sotomayor dissents. Kagan joins. Jackson dissents. And so the 3 liberal justices all disagree with this, of course. And so it's a 6-3 opinion. Let's see specifically what the court held in their ruling. They tell us Harvard and North Carolina's admissions violate the Equal Protection Clause of the 14th Amendment. So the court says because the students comply with standing requirements, we're going to hear the case. They say that the students do have standing, and so this case will be heard. Next, we ask ourselves about the 14th Amendment. And what does it say? Well, the 14th Amendment was created after the Civil War as part of the Reconstruction Amendments, and it says that no state shall deny to any person the equal protection of the laws. Proponents of this clause say it is foundational, and it's not permitting any distinctions of law based on race or color, which would not be an equal protection of the law. It would only be applicable to one race or one color. Any law which operates upon one man, they maintained, should operate equally upon all. And so accordingly, as this court's early decision interpreting the Equal Protection Clause explained, the 14th Amendment guaranteed that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. The court continues. The majority writes, despite the early recognition of the broad sweep of the Equal Protection Clause, the court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was in many parts of the nation, unfortunately, a regrettable norm. This court played its own role in that history, creating in Plessy versus Ferguson this insane separate but equal doctrine. After Plessy, the courts labored with this doctrine for over half a century. Some cases in this period attempted to curtail the doctrine by emphasizing that they have to make it actually equal. Separate but equal means actually equal. But it was still not good enough. As the courts subsequently recognized, even racial distinctions that were argued to have no palpable effect subordinated afflicted students. And so by 1950, the inevitable truth became known. The 14th Amendment had begun to re-emerge. This separate but equal doctrine had to go. Why? Because separate cannot be equal. The court says the culmination of this approach finally came in Brown versus Board of Education. And there, the court overturned the separate but equal regime that the court established previously and invalidated all de jure racial discrimination by the states and the government. The conclusion reached by the court was unmistakably clear. The right to a public education must be made available to all on equal terms. The court reiterated that rule just 1 year later, holding that full compliance with Brown required schools admit students on a racially non-discriminatory basis. But in the years that followed, Brown's fundamental principle that racial discrimination in public education is unconstitutional reached other areas of life. For example, state and local laws requiring housing or segregation in busing or segregation in beaches or bathhouses, all these types of laws had to go. Eliminating racial discrimination means eliminating all of it. And so accordingly, the court has held that the Equal Protection Clause applies, quote, without regard to any differences of race or color or nationality, and is universal in its application. And for the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to another person of color. And any exceptions to this guarantee provided by the Equal Protection Clause must survive a very daunting two-step examination known as strict scrutiny, meaning that the law has to absolutely be necessary to achieve a compelling government interest to very high standards, meaning there's nothing else you can do in order to get this done. And acceptance of race-based state action is rare for a reason. We don't let it survive that. It's called strict scrutiny. We analyze a law. If it comes out and it's racist in its approach, if it puts two people in different buckets based upon something like their skin color, we hold it to a very high standard. Saying distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. This court first considered whether a university may reach race-based admissions in a prior case. It was a very splintered decision, and it produced 6 different opinions out of the court. That case was called Bakke. Justice Powell's opinion for himself alone would really become the touchstone for constitutional analysis. A fractured court with all the judges. This doesn't happen often, but sometimes they'll all have their differing opinions. And what you'll do is you'll cobble together what you think the summation is, the totality of them. You'll say, okay, well, they all kind of agree on this point, so we'll write a law that fits this, and that way it fits the Supreme Court. So here, after rejecting 3 of the universities, 4 justifications is not sufficiently compelling, Justice Powell turned to its last interest asserted to be compelling. He said, well, all this is complicated, but obtaining benefits that flow from a racially diverse student body, that's the one. He found that interest to be a constitutionally permissible goal for higher education, which was entitled to academic freedom and to make its own judgments to create the selection of its student body. But a university's freedom was not unlimited. Racial and ethnic distinctions, the judge said, are inherently suspect because we know it's a strict scrutiny thing that we've already established from SCOTUS jurisprudence. Judge Powell explained an antipathy toward them was deeply rooted in our nation's constitutional and demographic history. Accordingly, a university could not employ a 2-track quota system. In other words, they can't say we want, 50% white people, 50% black people. They have to do it differently. They could use race, but it could operate as a plus in an applicant's file. So you can't discriminate against somebody, but you can give them a plus based on the race. Even then, it had to be weighed in a manner that was flexible enough to consider diversity and all of the other qualifications. But for years following this case, lower courts struggled to determine what to do. Was this binding precedent? We don't know. The court was split. So then another case came about, Grutter. The court for the first time then endorsed Justice Powell's view. They said, well, that one sounds good. We'll go with that, guys. That a diverse student body is a compelling state interest that justifies the use of race. So that strict scrutiny standard, that it has to be necessary in order to accomplish something, and it's the only thing we can do, and it's the least restrictive thing that we can do, is satisfied. The Grutter's majority analysis tracked Powell's in many respects, including in its insistence on limits and how they consider race. Those limits, they explained, were intended to guard against the dangers of a race-based government action that it portends. The first risk is that it's going to actually turn into illegitimate stereotyping. Admissions programs could thus not operate on that belief. Another risk would be that it would be used not as a plus, but as a negative to discriminate against those racial groups that were not the beneficiaries. A university's use of race, accordingly, could not occur in a manner that unduly harmed non-minority applicants. And so to manage these concerns, the court is still trying to come up with almost like legislation. It's bizarre. But to manage these concerns, Grutter imposed one final limit on race-based admissions programs. At some point, the court held, they must end, recognizing that enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection. The court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary because we'll have racial harmony. Things will be progressing, actually. 20 years have passed since Grutter. No end to race-based college admissions in sight. But the court has permitted race-based college admissions only within the confines of narrow restrictions. Such admissions programs must comply with strict scrutiny, the highest standard, may never use race as a stereotype or negative, and must at some point end. And so respondents' admission systems, meaning Harvard and North Carolina, their systems fail every one of these, and therefore must be invalidated. They say Harvard and North Carolina fail to operate their race-based admissions programs in a manner that's sufficiently measurable to even survive review, to permit judicial review under strict scrutiny. So we can't even really analyze it because it's hard to even measure it. First, the interests that Harvard view as compelling, they say, we have to do this. We have to have a diverse student body. Otherwise, something bad's going to happen. It's very compelling. They say it cannot be subject to meaningful judicial review. We can't even see that. Those interests include training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, preparing engaged and productive citizens. Those are their goals. Now, while these are commendable goals, they're not sufficiently coherent for the purposes of strict scrutiny. Knowledge based on diverse outlooks. The heck does that mean? Engaged and productive citizens. Like, that sounds great, but it's all just fluffy language. The court says it's unclear how courts are supposed to measure any of these goals. And so if we're going to be putting people into buckets based on race, we need to make sure that this is absolutely necessary. Or if they could, to know when they would have been reached so these racial preferences end. At what point does society have enough diverse outlooks? And at what point are our citizens engaged and productive enough as a result, literally as a result of this affirmative action? The elusiveness of Harvard's asserted goals is further illustrated by comparing them to other recognized compelling interests. Here's another example of an answer that is a good answer. Courts can discern whether temporary racial segregation of inmates, for example, will prevent harm to those in prison, but the question is whether a particular mix of minority students produces engaged and productive citizens and effectively trains future leaders is standardless. So second, they say Harvard and their admissions programs fail to articulate a meaningful connection between the means they employ and the goals they pursue. So even if you do want a diverse and engaged citizenry, how can you say that that is directly caused by your admissions program, such that society benefits? They say that to achieve these educational benefits of diversity, respondents measure the racial composition of their classes using literal racial categories that are plainly overbroad. For example, there is no concern for whether South Asian or East Asian students are adequately represented as Asian. They don't care. They say it's arbitrary and undefined, and the use of Hispanic, or it's under-inclusive. There's no category at all, even for Middle Eastern students. Don't even get a category. Where do they go? So the unclear connection between the goals that respondents seek, meaning Harvard wants a diverse and engaged student body, but the Middle Eastern students don't really count, and the means they employ preclude courts from meaningfully scrutinize their programs. So the universities, they respond, they say, hey, just trust us, okay? We're Harvard. We're smart. They assert that universities are owed deference when using race to benefit some applicants but not others. And while this court has recognized a tradition of giving deference to universities and their academic decisions, it has made clear that deference must exist within constitutionally prescribed limits. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is concrete enough to allow the courts to review what you're doing such that it passes the protections required by the Equal Protection Clause. They say that Harvard and North Carolina, their race-based systems also fail to comply with the Equal Protection Clause, the command that race never be used as a negative, and that it may not be used as a stereotype. The First Circuit, the Court of Appeals, found specifically that Harvard's consideration of race actually resulted in fewer admissions of Asian American students, who I think are at the top of the discrimination list. Respondents' assertion that race is never a negative factor in their admissions, that cannot withstand scrutiny. College admissions are zero-sum, and a benefit provided to some applicants but not to others necessarily advantages the former at the expense of the latter. Respondents Harvard and their programs are infirm for a second reason as well. They actually require the stereotyping, the very thing that our prior case forswore. When a university admits students on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. Such stereotyping is contrary to the Constitution. Harvard also says that this is justified, but the court responds explaining, no, this lacks a logical endpoint as well. There's no end in sight. Harvard suggests that the end of race-based admissions programs will occur once meaningful representation and diversity are achieved on college campuses, whenever that may be. Such measures of success amount to little more, the court says, than comparing the racial breakdown of the incoming class and comparing it to some other metric like the racial makeup of a previous class or the population in general, and whether there is some proportional goal has been reached. Like, is there a perfect chemistry balance? We have this many of every color here, and so now this is the perfect environment for us to learn. And everybody in that university is just going to be little Einsteins walking around solving quantum physics. The problem with this approach is well established. Outright racial balancing is patently unconstitutional. Harvard, second endpoint, they say, well, it's going to end at some point once society is sufficiently diverse enough. But the court says, well, we can't measure that. There's no real standard when we're going to get there. Do you have another measure? They say, sure. When students receive the educational benefits of diversity. Well, when students are all getting the benefits of diversity. What does that even mean? As explained, it's unclear how a court is supposed to determine if or when those goals would be adequately met. They also say that the 25-year expectation should also be allowed to continue until 2028. So they're just saying, well, it's this one or this one, but if not, at least let us go to 2028. Obviously, the court is not going to do that. So they rule, because Harvard and UNC's admissions programs lack sufficiently focused and measurable objectives that actually warrant the use of race, they unavoidably employ race in a negative manner, they involve racial stereotypes, and they lack meaningful endpoints, those admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. At the same time, nothing prohibits universities from considering an application's discussion of how race affected the applicant's life, so long as that discussion is concretely tied to a quality of character or unique ability that the particular applicant can contribute to the university. All right, so this is a little bit of a saving grace line for this. Now, we're going to see how these universities and colleges twist themselves into pretzels to try to continue to be race-based application programs with that sentence. Many universities have for too long wrongly concluded that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. This nation's history and constitutional history does not tolerate that choice. Therefore, the First Circuit Court of Appeals is reversed and remanded down for further proceedings. Signed 6-3 opinion, conservatives all joining against the left in gutting affirmative action, saying it's a racist, at least an application at Harvard and North Carolina, it's a racist approach that doesn't survive strict scrutiny because it is not measurable, it cannot be scrutinized by the courts. So that's the majority. Now, I want to fast forward and take a look at Thomas's opinion. Judge Clarence Thomas writes a concurring opinion. He says, in the wake of the Civil War, the country focused its attention on restoring the Union and establishing the legal status of newly freed slaves. The Constitution was amended to abolish slavery and proclaim that all persons born in the U.S. are citizens entitled to the privileges and immunities under the Constitution. Because of the second founding, our Constitution is colorblind and neither knows nor tolerates classes among citizens. This court's commitment to that equality principle has ebbed and flowed over time. After forshaking the principle for decades, offering a judicial imprimatur to segregation and ushering in the Jim Crow era, announcing the primary schools in Brown versus Board of Education must either desegregate or else close their doors, was a step. But it then pulled back in Grutter versus Bollinger, permitting then universities to discriminate. But now, two discriminatory wrongs cannot make a right. I wrote previously in Grutter explaining that the use of race in education admissions decisions, regardless of whether it was intended to help or hurt, violates the 14th Amendment. In the decades since, Thomas says, I've repeatedly stated that Grutter was wrongly decided and should be overruled. Today, and despite a lengthy interregnum, the Constitution prevails. And because the court applies genuine strict scrutiny here, I join the majority opinion in full. He's only writing differently to offer a separate originalist view to clarify that all forms of discrimination based on race, including so-called affirmative action, are prohibited under the Constitution, and he writes to emphasize the pernicious effects all the discrimination brings. Judge Clarence Thomas celebrating a big victory because he has been on this for quite some time, and the Supreme Court of the United States takes a sledgehammer to the affirmative action concept that Harvard and North Carolina were employing, and this ruling will have serious effect throughout the rest of the country as all of the other schools and colleges that don't come into compliance with this will now be subject to litigation. So a big victory, and the Supreme Court will continue to come under scrutiny. I can't even begin to imagine what we'll see from the left as they continue to try to delegitimize what the court has done here.